Dear students, we have come with a new module, mistake. What is mistake? Mistake, you have done some mistake. So when you're doing some mistake, the validity of the contract is affected. So that is what we are going to see in this module. Now, what is the meaning of mistake? Lack of mutuality of minds due to mistake. See, one of the essential conditions for a valid contract is that there should be consensus added up, mutuality of mind. Both the parties should agree on the same thing in the same sense. So that meaning, if it's for the buying of the apartment, so that meaning 3 BHK. So the person is also discussing about 3 BHK. The builder is also discussing about the 3 BHK, the common amenities, everything. So then it's mutuality of mind. If there is one person understood something in one sense and the other person understood in a different sense, customer is asking for 3 BHK, builder is negotiating for 2 BHK, then it is a mistake. Now, what are the types of mistake? Sections 20, 21 and 22 of the Indian Contract Act 1872 divides mistakes into two types. One is mistake of law and mistake of fact. Now, what is mistake of law? Mistake of law meaning anything. See, you know that validity of the check is 3 months. Securities and Exchange Board of India Act, there are certain rules and regulations. Companies should follow. Stock brokers should follow. Stock exchanges should follow. Companies Act, they have to follow certain rules and regulations as per the Companies Act. These are the laws of the country. When you are related to that act, you have to follow the rules and regulations. So if it's a mistake of law, we are dividing into two: mistake of law of the country and mistake of law of a foreign country. Mistake of law of a country meaning you are violating the rules and regulations of the country. And mistake of law of a foreign country, you are traveling to a foreign country, you are violating rules and regulations there. See, for example, in Dubai, if you drink, you are not allowed to drink in public. You are not allowed to litter the place. Same in Singapore also. You are not allowed to litter the place in Singapore. So these are, if you are violating, you have to pay the fine. Mistake of law of the country meaning you are giving a check, thinking that validity of the check is 4 months. Then after 3 months, it will become a stale check. So this is mistake of law and mistake of law of a foreign country. Now, mistake of law, what is the legal consequences? No relief we will get for ignorance of law. When you are living in a country, you are supposed to follow the rules and regulations. So there is one statement, ignorantia juris neminum. That meaning is that ignorance of law is not an excuse. So especially you have to remember the validity of the check, the traffic rules and regulations. When a company's memorandum of association, articles of association, the stockbrokers rules and regulations, the Anti-Prevention Money Laundering Act, what are the rules and regulations? All this you have to remember. So these are the laws of the country we have to follow. Mistake of law of foreign country is treated as a mistake of fact. That meaning it is excusable if you say that, if you are able to convince that you are a traveler, you are a tourist, you are not aware of that. But in all countries, you will not be excused for that. So the contract will be void when you are violating the rules and regulations of a foreign country. But it's advisable always to follow the rules and regulations. When you're traveling to a foreign country, you understand the rules and regulations either from the travel agent or from the website or people who they are working there already. So you please understand and follow the rules and regulations. It's very important. Now, what is mistake of fact? Mistake of fact is divided into two: bilateral mistake and unilateral mistake. The simple meaning is that bilateral mistake, both the parties are at mistake. Unilateral mistake, one party has made the mistake. So bilateral mistake, you have to remember, mutual mistake or a common mistake. Both the parties to the contract made the mistake. That meaning parties misunderstood each other and are at cross purposes. For example, one party want to sell an Alto car. The party who's coming as a buyer, seller want to sell an Alto car. The buyer is thinking that it's an Eon car. Parties and misunderstood each other. They have not clarified that. So the contract will be void. So the best example is seller is selling something which he or she is not entitled to sell. Imagine a person got a power of attorney. That meaning he has no right to sell that property if it's not mentioned in the power of attorney. Usually power of attorney is just for paying tax and to take care of the property. If it's not given in the power of attorney to sell the property, He has no right to sell that. If he's selling that, it's a bilateral mistake. Now, what is unilateral mistake? One of the contracting parties mistaken as to the matter of fact. So the contract is valid if it is not caused by misrepresentation. We know that misrepresentation, you are trying to give a wrong representation about the thing. So if you are giving for the sale of an apartment, you are selling that occupation certificate is there. That's very important. If occupation certificate is not there, whatever the representation given by the builder or his agent is totally wrong. It is an unilateral mistake. The customer will buy the apartment thinking that occupational certificate is there. Because it's an important document. As per section 22 of the Indian Contract Act 1872, see one example, this is contract is valid if it is not caused by misrepresentation in the case of unilateral mistake. If you take another example, see you have a person entering into an auction. The auction is only for 1 year. He auctioned that liquor license or whatever that auction there, thinking that it's for 3 years. So that is unilateral mistake. The company made it very clear auction license, or the government made it very clear auction license is for 1 year. So the party auctioned it thinking that it's 3 years. So here it is a unilateral mistake. One party is at mistake. Now, void agreements if consent is given by party under mistake. So here you have to remember mistake to the identity of the party contracted with. So here one case decision will explain this. Void agreements. See the case decision, said versus but. Said is a very unimaginable critic of a theatre company. Whatever the shows they will give, Mr. Said will criticize like the shows like anything. So the managing director of the theatre company mentioned that when he is coming for the theatre company, if he is approaching for buying the ticket, you should not sell the ticket to him. So aware of this, Mr. Said, what he did was, he sent his friend to buy the ticket. So he got the ticket and he wanted to enter the theatre when the show is on. So but the theatre agents or the security guard stopped him saying that you are not allowed to enter. We got the clear instruction from managing director not to allow you inside the theatre because you are a critic. Then he decided he will go to the court. He will go to the court saying that he is not allowed because he got a valid ticket. He is not allowed entry into the theatre. But the case decision was not in favor of Mr. Said because the theatre company was very particular. We are not going to sell ticket to Mr. Said because he is a very good critic of the theatre shows. Whatever they are doing, he is used to criticize badly. So that was the reason. But here you have to remember that identity of the person is very important because the managing director gave the identity of the person. Don't sell ticket to Mr. Said. So this here you have to remember that identity of the person is important in this. Next is mistake to the character of the written agreement. Mistake as to the character. So here also, if the agreement, if consent is given by party under mistake. So second example is that an elderly person, Mr. Foster versus McKinnon. That is 1869 this happened. Mr. Foster, he's partly blind. So he signed an agreement saying that it's a guarantee statement. But what happened? It was not a guarantee. Actually, it was a bill of exchange. So he signed that document under mistake. Now, why he signed? His eyesight was partially affected. He was not able to understand the document. So here, this is a void agreement because consent is given by the party under mistake. So two cases when consent is given by the party under mistake. One is we have learned the case said versus but. In that you have to remember identity of the person is very important. In the second case, Foster versus McKinnon. Here you have to remember the document was wrong because he got partial eyesight. He is not having full eyesight. So he is partially blind. So he signed the statement thinking that it's a wrong document. On one more happy news I want to share with you. Students were asking me for the PPT. So all the PPTs for all the modules we have uploaded. It is available in the description box. Please refer the PPTs and explain and learn the explanation with the help of the PPTs. So it will be a good learning experience. Thank you for listening. Happy learning.